All right. Hi. Good morning. Just to have you guys know, we have announced that coming up there will be this bad decision, in my opinion, bad decision by the Caribbean Court of Injustice. And I say injustice because this is precisely what has been happening, particularly in the case of the elections petitions, and not just elections petitions, but during the elections, electoral matters um, post 2020, March 2020 elections. And we all saw what direction the court was heading in. And so, even as we await today's decision, um, let's not be fooled. Let's not be fooled at all about what you are about to hear from those guys at the CCJ. It is not that the decision was is totally unexpected. You guys you guys knew, well, some of you should have known that the court would have been consistent in its injustice against the Guyanese people, and so today's decision is no surprise, and especially also with the parties to the case were told. Usually, they are informed as a matter of courtesy, and they're basically supposed to keep that a hush hush, so to speak, until as a matter of courtesy and ethics. And unfortunately, we don't see those in the installed regime of having any sort of ethics and any sort of ethics or professionalism within them. Hence the reason. Hence the reason that Anil Nandalal was able to um, make a post on his Facebook page telling his support base that this is the decision. Any other part of the world, Anil would have been brought before the disciplinary committee, that is the Bar Association. Unfortunately, Guyana does not have a legal bar association. Guyana has a bar association, yes, but they are they're not legally um, registered to discipline lawyers. It's just a private organization of a few lawyers who sit down, and you would find them making comments and press statements about political matters. And all of those statements are in favor of the PPP. So the Guyana Bar Association is not a legal entity. They do not represent lawyers. Again, and we should know that Guyana does not have a bar association. Again, Guyana does not have a bar association. So as we prepare now to have to see what's going on at the CCJ, um, and to listen to what they have to say, I just will take a quick 30 seconds break, and we will go live in Trinidad and Tobago and hear what those guys of the Guyana, I'm sorry, the Caribbean Court of Injustice has to say. Let me say good morning to all of you. I see you're all fired up already. Francine Cruz, Guyana Rumbar Association. Francine is always correct. Give my regards to the other folks over at the um, Long Island Institute for the Elderly. So good morning to Francine Cruz and GT, Root Girl, and Jeanette and Ingrid and Desiree Simons and Glenford. All of you guys. We'll be right back with that injustice decision coming from the Caribbean Court of Injustice. Again, if you're now joining us, it's a decision that's going to be made officially. We've already heard through the installed Attorney General about the decision. Obviously, it's in favor of the installed PPP regime. And so this is what this matter is all about. We're waiting for these guys to get ready so that they can make the announcement that we already are aware of, and even prior to Anil Nandalal doing what he did illegally, that is. But there's no one there to sanction him, so he's going to continue to make these silly decisions, questionable decisions, by posting what should not have been posted on his Facebook page. We see the Honorable Justice Anderson is seated. We see some of the lawyers there and some of those who are disguised as lawyers. We see them seated there awaiting the official announcement. There is actually no volume at this time, so you can't hear anything. Don't panic. You're just hearing me for now. Um, and if you can share the link, we appreciate that. There are some folks who are being restricted from commenting on this section here. Just be advised that we have no control over that to some extent. Yes, those who misbehave can be blocked, but if you're a good follower, and you good followers know who you are, and when I say followers to the page, if you're having difficulties in terms of making a comment, just know that it is at Facebook and not us trying to prevent you good folks, from commenting. Again, we are waiting. We do not have any volume at this time, and we just have to sit and wait for we just have to sit and wait for the Caribbean Court of Injustice to officially make its decision public, as we already know. Um, I'm reading some of your comments, even as we await this um, so-called decision. And if you were following this entire saga, you'd know that it's a decision that they had to. They had no other choice but to make this decision. But we'll get to hear, about the decision. We'll get to hear why they arrive and how many justices, whether it's all of them. Um, I'm not sure as yet. I'm just not sure as yet. So we see the Honorable Justice Anderson is back. He's on his phone. If we want to play some games, we could pretend as though I'm on the phone with him and we're talking. And, yes. Okay. So the decision is okay. Gotcha. Okay. So we can, the folks at the Caribbean Court of Justice do what they do. And for those of you who are not aware, all or most, of the countries in the Caribbean are not part of um, they're not part of this Caribbean Court of Justice. They're just not part of it. Um, and notice some folks are giving their comments out there.
Yes, Judge, I'm hearing you.
So let's head over now.
So you are hearing me? Oh.
Yep, they seem to have some technical difficulties there at the Caribbean Court of Injustice. We notice Justice Barrow is already seated. We see some of the other attorneys and lawyers and those who disguise as lawyers as well. They're all set and ready to hear what all of them already have heard. We see Justice Witt is already there. I want to bet that some of them have to have ruled against the appeal. You see Roysdale Ford is there, senior counsel, representing the coalition in this matter. So if you can share the link, we'd appreciate it. Just like you guys have been sharing the link about Guyanese and all of the memes about Guyanese preparing to head to London and all these different things. You can share this. This is important information enough for all Guyanese to hear what happened to them and how they've been railroaded by the Caribbean Court of Justice.
What 4 more persons to do?
Yes, I think we could continue. I think
continue, right? So the next person, I think, I don't know. We had Mr. Williams and we had Mr. Jonas. I'm not sure where we are because I was not following at the time.
we have Mr. Kurt de
Council,
Silva.
please, you would know where we are. Please make the appearances as per usual. Thank you.
You haven't had Mr. Jonas yet, Your Honor, so allow me to come the line,
Sorry,
please.
Mr. Jonas.
And appear for the 8th, Sasha Kisoon. Thank you very much.
May it please, Your Honors, I'm Ganesh Shira, and I appear for Vishnu Bandhu, the representative of the United Republican Party.
May it please, Your Honors, Mal Run appearing for Jonathan Yearwood, who is a representative of a new and united Guyana.
Good morning, Your Honors. May it please the court, Kashir Khan with Mohammed Khan, Ivan Alert, Kalish Lokman, and Joshua Abdul, and we appear for Shazam Ali.
Okay, I think we got through the list. So I think we are ready then to deliver a judgment. There is a matter of seriousness that we need to go through, but I want to have the judgment delivered first, and then we will speak about that other matter about a premature announcement of the judgment as far as we have heard. But let's not talk about that now. Let's deliver the judgment. So I will ask Justice Anderson to deliver the judgment.
Thank you, President, and good day to everybody. General elections and regional elections were held in Guyana on 2nd March 2020. After the declaration of the results in August 2020, election petition 99P 2020 was filed on 15 September 2020, challenging the validity of the results and seeking an order that the elections be deemed unconstitutional, null, void, and of no legal effect. Election petition 99P 2020 along with election petition 88P 2020, were heard by Chief Justice Roxanne George, acting. The Chief Justice, at a case management conference, raised the issue of whether Mr. David Granger, representative of a Partnership for National Unity and Alliance for Change, was a proper and necessary party to the petition, and whether Mr. Granger had been properly served. As a proper and necessary party, Mr. Granger should have been served with election petition 99P 2020 and the supporting documents within 5 days of filing of the petition, as required by Section 8 of the National Assembly Validity of Elections. Validity of Elections Act, Elections Validity Act, and Rule 9.1 of the National Assembly Validity of Elections Rules, Election Validity Rules. That is by 21 September 2020. In fact, Mr. Granger had been served on 25 September 2020. Accordingly, the Chief Justice dismissed the petition, ruling it was a nullity. The petitioners, now first and second respondents, appealed against the Chief Justice's decision. The Attorney General and Mr. Jagdeo, the appellants, objected and applied to strike out the appeal on the ground that the Court of Appeal lacked jurisdiction to hear and determine the appeal. The court's election petition jurisdiction is to be found in Article 163 of the Constitution. According to Article 163(3), an appeal to the Court of Appeal shall lie from the decision of a judge of the High Court granting or refusing leave to institute proceedings for the determination of any question referred to in Article 163(1), or from the determination by the High Court of any such question or against any order of the High Court made in consequence of such determination. The Court of Appeal, by majority, found that an appeal lies to the Court of Appeal through Article 123 of the Constitution and Section 6(2) of the Court of Appeal Act, and that the exercise of the ordinary jurisdiction of the court was not excluded by the special jurisdiction created by Article 163 of the Constitution. The Court of Appeal accordingly held that it did have jurisdiction to entertain the appeal. The Attorney General and Mr. Jagdeo then appealed to the Caribbean Court of Justice. The judgment of the court was delivered by Anderson JCCJ, with whose reasoning Witt JCCJ and Rajnath Lee JCCJ agreed. The overarching issue was whether the Court of Appeal was correct to hold that it has jurisdiction to hear an appeal from the decision of the High Court dismissing the petition on ground of non-compliance with the Elections Validity Act and the Elections Validity Rules. The court noted that there are 3 possible grounds on which such jurisdiction may be based. The first ground is Article 163 of the Constitution and the Elections Validity Act and Rules. Anderson J. CCJ explained that the fundamental proposition to be derived from Article 163 and from the Elections Validity Act and Rules is that they establish a comprehensive regime for challenges to an election. Election Petition 99P 2020 had to be determined in accordance with this framework. Rule 9 was breached, and so it fell to the High Court, the court before which the petition had been presented and in which exclusive jurisdiction was vested by Article 163 of the Constitution and Section 3.1 of the Elections Validity Act, to determine the issue of non-compliance. It could not be accepted that proceedings which began in the High Court under this exclusive, exclusionary, and special jurisdiction for dealing with election petitions suddenly transmogrified into ordinary civil law proceedings on appeal. Neither is it permissible to depart from or import into, by implication, a jurisdiction not created in the article. The court emphasized that Article 163.3 circumscribes the right to appeal decisions of the High Court in election petitions to only 2 circumstances. The Chief Justice struck out the petition on the basis that there was improper or late service on Mr. Granger. Her decision did not fall into either of those 2 circumstances, and thus no appeal was possible. As to whether jurisdiction could be based on Article 123 of the Constitution, coupled with Section 6 of the Court of Appeal Act, the majority disagreed for 3 reasons. First, the special elections jurisdiction in Article 163 of the Constitution and the Elections Validity Act and Elections Validity Rules must prevail over the general civil law proceedings jurisdiction contemplated by Article 123 of the Constitution and Section 6.2 of the Court of Appeal Act. Secondly, there exists the broad and fundamental principle that general provisions in a statute must yield to specific provisions. And thirdly, any tension between Article 163 of the Constitution and Section 6.2 of the Court of Appeal Act concerning the election jurisdiction must naturally be resolved in favor of the Constitution. As to the third and final ground, Anderson J. CCJ noted that there may be an exception to the rule as to the Court of Appeals jurisdiction in order to maintain the integrity of the Constitution, a possibility considered by this court in Coffey and Skerritt. He opined that procedural as well as substantive errors may be a basis for arguing that there should be a right of appeal to the Court of Appeal, but that the threshold for making such an argument is necessarily very high. In this case, however, there was no real suggestion from the respondents that the Chief Justice's decision in dismissing the petition for want of proper service could support an argument that could justify invocation of the exception. In an opinion that concurred in the result, but differed as to reasons, Barrow JCCJ observed that it must be considered that while exclusive jurisdiction is given to determine primarily the validity questions listed in Article 1631, the general jurisdiction is not excluded from operating when the question being determined is not a validity question under Article 1631. The Chief Justice's decision to dismiss the petition as a nullity in this case demonstrates that what was appealed in this case was not a validity question under Article 1631 with its restricted right to appeal, but an ordinary question of law regarding service of process as required under the Elections Validity Act and rules. The invocation of jurisdiction was not solely in relation to validity questions under Article 163. He continued that Article 1631 was not in play in this case, but rather Article 1634, which gives power to Parliament to legislate with respect to the practice and procedure of the High Court in relation to jurisdiction and powers conferred upon it by or under Article 1634C. In crafting these legislative provisions, Parliament included Section 42 of the Elections Validity Act and Rule 21 of the Elections Validity Rules, which gave the court the same powers, jurisdiction, and authority in election petitions, quote, as if the proceedings were an ordinary action, end quote. These provisions were thought opposite to answering the question of whether the decision to dismiss the petition is subject to the Supreme Court's general jurisdiction in the same way as an ordinary action. In an ordinary action, a dismissal of a claim for improper service would be subject to consideration under the general appellate jurisdiction of the Supreme Court. Of course, that did not mean that an appeal lies against the decision, but rather that the decision may be reviewed to decide whether the right of appeal given by the High Court or the Court of Appeal Act includes that decision. In this case, several indicators made it clear. The Chief Justice's order dismissing the petition was an order made in chambers. Section 6(2)(a)(1) of the Court of Appeal Act places an order made in chambers in the same statutory boat as an order made in summary proceedings, where no right is given to appeal to the Court of Appeal. The result must be that the purported appeal by the then petitioners against the dismissal by the Chief Justice of the petition in this case as a nullity is itself a nullity because there was no right of appeal to the Court of Appeal. In concurring, Jamadar JCCJ agreed with Barrow JCCJ that the decision to dismiss the petition for failure to comply with statutory requirements as to service was an exercise of judicial discretion pursuant to the powers, jurisdiction, and authority provided for by Section 42 of the Elections Validity Act and Rule 21 of the Elections Validity Rules. Thus, any right of appeal as to service of an originating process is to be sought within the ordinary powers, jurisdictions, and authority of the court incorporated by Section 42 of the Elections Validity Act. An appeal of such a decision does not lie in the Court of Appeal, but to the full court. He observed that in Guyana, the deep basic structure and core constitutional values and principles to be found in Guyanese constitutionalism should guide a court when faced with choices as to multiple interpretations of statutory provisions. This is especially true in relation to provisions that implicate core constitutional values such as free and fair parliamentary elections. He suggested that the narrow jurisprudential issue in this case, in this appeal, needs to be placed, contextualized, and understood through the lenses of democratic governance in Guyana, the role of the courts, and the learning to be found from authorities such as Hines against R, Williams against Mayor of Tenby, and R. Willis against Parliamentary Election Court. Sorry. As to the interpretation of Section 42 of the Elections Validity Act, Jamadar JCCJ explained how Section 42 could be constitutionally reimagined and reinterpreted by liberating the meaning of subject from its colonial mindset. By doing so, Section 42 becomes accommodating of a more permissive, purposive, and inclusive interpretation and application that permits an appeal to the full court. This approach to Section 42 is reasonably justified in the particular circumstances of this case, where the issue is whether a right of appeal lies from a decision striking out an election petition for late service. Now, having regard to all the opinions expressed in this case, the appeal was accordingly allowed and the decision of the Court of Appeal set aside. The court ordered that each party bear their own costs. Thank you, President.
Thank you, Justice Anderson. I think, well, it's a good thing that we had a decision with sound, which could make it a sound decision. But there's something more serious to discuss, which is it was brought to our attention that this decision of the court, which was an advanced copy was provided to counsel, as is the custom of the court, which is a service of the court, that decision was already publicized on the Facebook page of the Attorney General. That is what was brought to our attention, which is, of course, a very serious and unacceptable thing. What we want to know, of course, this was brought to our attention, so I would like to invite the counsel for the Attorney General, I suppose that's Solicitor General Hawke, to give his views on what happened.
Oblige, Your Honors. Your Honors, first we like to place our sincere apology to the members of the court and to our learned colleagues. But what transpired, as I've instructed, and I should say that the learned and Honorable Attorney General was traveling and is on government business in Barbados, and I'm instructed that an unauthorized note, the judgment wasn't published, an unauthorized note was published on his Facebook page, and when it was brought to the attention, it was immediately pulled. We just like to say for the record that it was not the judgment. A note was placed on his Facebook about the judgment, and be that as it may, Your Honors, we would like to place on the record our most sincerest apology to yourself, the President, and other members of the panel. We would like to say it was in no way intentional. It was in no way intended to bring the administration of justice of the court into disrepute. And we plea and we hope that this court will find grace and forgiveness for that sincere error on the part of the administrator of the page. But that was the situation, Your Honors. It was an unauthorized publication of a note and not a judgment, but that in itself is still a breach, and we sincerely apologize.
Your Honor.
Yes.
Your Honor, Stelvin Peters, one of the co-counsels for the one of the respondents. Your Honor, what I would say in this case is that irrespective of whether it was the judgment itself, it was the content and the result of the judgment that was published. There was an implied undertaking in Canada, where I also practice law. We actually signed an undertaking prior to the release of these judgments that are embargoed, but the CCJ's practice is not that. But the undertaking still remains. What that premature release did, it was shared all over the internet. And what it did is it put the administration of justice into disrepute. Because if Your Honor's staff read the comments, it almost seemed like the Attorney General had some privy, but we were not allowed to say that all lawyers got an advance copy of that judgment. We were not allowed to comment on it, but the comments with respect to the CCJ was not comments that puts the CCJ in a positive light. And so I appreciate the Solicitor General's apology. That page is the Attorney General of Guyana's page. The Attorney General of Guyana is the Chief Law Officer of the state. He's the representative, the leading counsel of the bar. What happened there was unacceptable. The apology is not accepted because it put the CCJ into disrepute. And those are my submissions.
Yes, anyone else who wants to shed a light on this? Mr.
President,
Yes?
before you ask about shedding a light, in what I heard, did the counsel for the Attorney General, apart from indicating the apology to the court, did he indicate to us that he would issue that apology publicly on the fora that the offending notification or notifications were posted. I'm just trying to recall whether that was stated to us or not.
Your Honor, if it pleases you, it was not, but that would not be a problem. We wouldn't have a problem going the additional extra step and putting it on the record on the Facebook page that was published. That it's a public apology that we're making. That is
Yes,
not
you heard Mr. Peters. The impression was created that okay, the Attorney General has some hidden line with the court. He gets this first, and no one else knows about it. We know that that is not so. But anyway, this is just an example of how these things may affect. Would you agree, Mr. Orr?
Your Honor, I'm in full agreement, and that is why I at the outset sought the court's kind indulgence for forgiveness and mercy and grace, because I fully understand the situation. That is as best as I can do. It has happened already, unfortunately, and we're placing our most sincere and profound apology for that error. And Your Honors, I leave it now to Your Honors' grace and judgment in that regard.
Yeah.
Mr. Hawk, for perfect clarity,
Yes, please.
can
Your Honor.
I take it that the Attorney General's chambers, the Attorney General will himself ensure that he's undertaking that an apology will be published?
That is the position, please, Your Honor.
Okay. Now, Mr. Peters, you were saying an apology is not sufficient. Okay, we now heard from the Solicitor General that the apology will be published. The Attorney General is undertaking to do that.
Justice Witt, may I interrupt you? I see Mr. Justice Anderson's his hands are up.
Yes, Justice Anderson.
Yes, thank you, President. And I have listened with great interest to what has been said. I was not aware of the breach of the confidentiality. I would say, sir, that this discussion is useful, no doubt. And we have heard what we have heard. However, there are much more profound issues at stake. And those issues, I do not believe, can be fully ventilated in this forum. I think the court will have to decide how to go forward in relation to the release of these advance copies, possibly generally, and certainly in relation to sensitive matters such as this one. And I believe that that's a discourse that the court should have with itself, led, of course, by our permanent president, to decide how to go forward. I really don't think that this forum, beyond what we have heard, is going to be very, very helpful in deciding how we go forward. I do take the point that we expect an apology from the Attorney General himself. No doubt that will be forthcoming. But beyond that, sir, I do think that this is a policy decision that we need to discuss and decide amongst ourselves. And I say that particularly in the context of the fact that we have another hearing which is upon us. And I have to do a couple of things before that hearing starts. So I would pray your leave and indulgence by suggesting that we, having heard what we have heard, defer the matter for consideration by the bench itself. Thank you.
Yeah, Justice Anderson, I was minded to withdraw shortly and discuss this, but given the time problem, I can understand that that might take too much time, but I think we have expressed ourselves clearly enough to make it very clear that this is totally unacceptable. And any further action of the court will be contemplated. For example, is it possible in cases like this to send an advanced copy in Guyana? I mean, this is really serious business, and we cannot have it. And this is something we will discuss in a broader form, because I think this is something that our president of the court also needs to be involved in. We don't take this lightly at all. And I'm sure that the last word has not been said yet. At least we have heard Solicitor General Hawke make the apology. His undertaking that the apology will be published. That's the first step. But if it is, whether it's enough or not, that is to be seen. So let that be the message.
Thank you, President.
Let that be the, yes?
I'm seeing Madam Justice Rajnath-Lee, and I'm seeing Mr. Mendes would have had his hand up. I don't know if we have the
Sure.
time based on what Justice
President,
Anderson has asked.
I'm afraid, President, that I may very well have to beg your excuse because I have another meeting which I have to attend.
Okay, but very shortly, Justice Rajnath-Lee.
Yes, I just wanted to say thank you, President. I will not be long at all. I wanted to say that apart from the apology and all of the other things that I've heard today, I am very concerned about the impact on the integrity of the court.
Yes.
And I would like counsel here perhaps to come up with something that will remedy that impact. It is a very, very serious matter. Thank you. That's all I wish to say. And I see Mr. Mendes has had his hand up for a while.
Mr. Mendes.
Thank you very much, Your Honor. Just to say in relation to a concern that Justice Witt had expressed about whether the impression might have been given that the court was communicating only with the Attorney General. Just to point out that I'm seeing on Facebook that the Attorney General had posted something that said that this is apparently subsequent to the Facebook post, that the judgment had been dispatched by email to all lawyers representing the parties.
Yeah. Okay, but apparently that impression was created. So it only comes to show how dangerous these things are. If we cannot have any trust in counsel or in the Attorney General's office, I'm not even speaking about the Attorney General himself, but you have to organize your stuff in a way that this cannot happen. That must be absolutely clear. So let me keep it at that. We will give further consideration to this situation by the court in total, and I suppose you will hear what the court will decide on this point. Justice Rajnath-Lee, your hand is still up, but that's not the
It's
idea.
only because I have not lowered it. Sorry.
Okay. Okay, so we'll keep it at that for now. But I think you will leave with the impression that the court is very displeased, and that is the correct interpretation of what we have said. So thank you very much for attending, and you, acting registrar, you could close the proceeding.
Thank you, judges, and thank you, counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Well, that court is stand adjourned. But just let you guys know that this court has not been adjourned as yet, meaning this court right here on 107.1 FM. We're very disappointed, very dissatisfied, and this would lead to a majority of the people of Guyana being dissatisfied, of course, and having no no sort of confidence in the Caribbean Court of Justice. Absolutely no confidence in the Caribbean Court of Justice as it pertains to the dispensation of justice. People are of the view that this is now described as the Caribbean Court of Injustice. All along, the people have seen the failure of the court to dispense justice on behalf of them. We see the political masquerading of cases in the form of judicial outcome and their decisions. People are of the view, rightfully so, that these decisions are discussed amongst the justices, and when they are being discussed, they also, the PPP operatives are privy to these supposed private discussions as to how the matter is going to, or how matters of political nature will be discussed and subsequently dispensed. In this situation, we saw ahead of the court's official decision on this matter pertaining to petition 99, appealed by the PPP, we saw on Anil Nandalal's page, on Anil Nandalal's personal Facebook page, that he placed this out there. And I'm going to say this to you guys. Anil Nandalal's page is managed by Anil Nandalal. There isn't anything going to go out and be published on his personal Facebook page without being sanctioned by Anil Nandalal. I repeat, nothing will be published on his Facebook page unless it is sanctioned by Anil Nandalal. And so the attorney Hawk, who is part of the AG's chambers, has said and tried to convey that impression that Anil knew nothing about this. In fact, that Anil didn't sanction it. And because Anil is away, I think he was in Rwanda or somewhere, he's traveling, taxpayers' money, having fun, and that he was totally unaware. And then when he became aware, he immediately ordered the taking down of this particular post. And if you're joining us now, the CCJ has admonished the installed Attorney General for this post. His lawyer has indicated that there will be an apology. It's probably going to be too late. We don't want an apology. And I've noticed one of the lawyers there, Selwyn Peters, actually said that he is not accepting that apology. Those justices in this Caribbean Court of Justice, at least they gave us the impression that they're upset. They're really upset about this particular situation by Anil Nandalal because they know the implication. And in any other part of the world, thousands of people would have already been in the streets, hitting the streets, calling for Guyana to be removed as a party to the Caribbean Court of Justice as their final court of appeal. In our Constitution, or in the Constitution of Guyana, there is no space for the Caribbean Court of Justice to be the final appellate court, the final place that makes the final decision, unless it was actually amended. I am unaware of that amendment. However, for our Constitution, the Constitution of Guyana says that the final appellate court is the Guyana Court of Appeal. And there is nowhere in Guyana's Constitution that says the final court of appeal is the Caribbean Court of Justice. Then all decisions made by the Caribbean Court of Justice should and ought to be deemed illegal. Again, I'm just saying I am unaware that there has been an amendment. In fact, any such decision to move a court or to have a court as a final decision maker, then that should be amended. So I'm not 100% certain, but it should be amended into the Constitution of Guyana. If it's not, then that's another matter. Just like the free education from nursery to university even though from nursery to university, when the PPP got into office, they just basically stopped the free education, free tuition at the university level of Guyana. So the point that I'm making there is, even though that is enshrined in the Guyana's constitution, that education at the university level is free, the PPP stopped that, and people had to, for 23 plus years, pay for free education. Pay for their university degrees at the Guyana University or the University of Guyana. So a lot of things, lots of things. I'm looking at some of your comments. You guys are rightfully so upset. We see everything that's happening. It's just Guyana is going downhill. And I really do mean it. I'm saying it with a Guyanese accent, not a British accent. Guyana is going downhill. And we cannot run away from that fact. All sort of jiggery pokery they're coming up with to make it look as though Guyana is on the right path of success and development and all. That is not the case. Guyana is going downhill. With regards to the lifting of the ban, because prior to 1992, Guyanese, I believe, there was no visa restrictions for England, and now that has been lifted. And so unlike what the PPP is trying to convey, this impression that it was a big deal and Air Finale, they got together and they fought for that to be done, and it's the first time in history it has ever, that is not so. Guyanese who were born prior to May 26 of 1966, folks like Theodore Adams and Otto Martin and all those guys who are up the hill in age, born when Guyana became, or before Guyana became an independent country, they were able to travel. I'm not sure whether they took that opportunity to travel to the United Kingdom, but they were able to travel. Others would have been able to travel to the United Kingdom sometime after 1980 as well, after 1986 as well, all throughout the Burnham regime, Burnham years in office. So all of these things that they're talking about is not at all. And that is why we need a more robust opposition. Opposition can get out there. Take, for example, and then when we beat up on the opposition, they get vexed. They get upset. The very thin-skinned folks in the opposition, lots of them. This particular press release, and mind you, the court was informed by members of the public. Not necessarily, I'm not sure if they were officially informed. Some of the justices are on Facebook, and some of them were informed. The court was informed directly via their emails. And that's the sort of action that we need. However, those in the opposition should have already called a press conference to denounce this particular matter right away. Call a press conference to denounce it and call for sanctions, not just an apology. Sanctions. Sanctions. That is why in a post that I've made earlier on my private page, that in any other part of the world, Anil Nandalal would have been sanctioned. And this is a high enough infraction to have caused his lawyer's license to be revoked or for him to be suspended for several years. Unfortunately, Guyana does not have a bar association, and who is there to sanction him? Who will sanction Anil other than the public? Who will sanction him? The Guyana Bar Association is a private entity run by a bunch, mainly PPP individuals, who sit down and drink rum all day in a bar, so it may appear. And the point I'm making with that is that that is the purpose of the Guyana Bar Association, a chit-chat group. It is not a legal entity. The Guyana Bar Association is not a legal entity. They cannot sanction lawyers or anything of that sort. But what they do, they issue press releases when it's of a political nature and when they are rushing out to defend the PPP, the installed PPP regime. But we haven't seen any sort of press release, or if we want to call it that, from the Guyana Barbecue organization, the Guyana Barbecue Association. Nothing at all from them. But let us take, for example, if this was the case and the coalition won, they should have won. There was a substantial amount of evidence to have them win this case, but because of what's happening at the Caribbean Court of Injustice, we see them favoring, and this is a consistent, this consistency of the court in favoring the PPP throughout the election, post-election matters. They want to be consistent because the CCJ appears to be a party to the changing of government, the illegal changing of government of Guyana. But let us assume, let us, for argument's sake, say that if this release came from Roysdale Ford or Selwyn Peters or one of the other lawyers for the opposition folks, if this release came from one of those lawyers, the Guyana Barbecue Association, the Guyana Barbecue Association would have been issuing or would have already issued a statement to the effect. So we're seeing the one-sidedness of these folks, but then again, nobody has confidence in anything coming from the Guyana Barbecue Association, which is not a legal entity to represent lawyers in Guyana. All right, so what else it is we can say about this matter is that we are going to await some sort of sanction from the court, by the court, on Anil Nandalal. The court, the justices are saying that they're upset. And of course, they are going to be upset because they know that they have lost all confidence. The people have lost all confidence, in the Caribbean Court of Justice. And if I had my way, I would have been leading a massive protest in front of CARICOM right now to send that message to the Caribbean Court of Justice. And all those supporters of the People's National Congress reform, the coalition, and so forth, we see a lot of the supporters on Facebook. We see a lot of Facebook experts. And those of you, don't get me wrong, don't read me the wrong way. A lot of them are in Trinidad and Tobago. And just like the energy that folks have to make all memes and so forth about London and who's going to London and Guyanese can't make it to Linden or Latham and they planning and going to London and all manner of things. I wish the same energy. And mind you, I like the memes. Don't get me wrong. I like the little sense of humor that our people have, albeit under the circumstances in Guyana, economic depression, racial disharmony, Guyana being a semi or almost close to be an apartheid state under the installed PPP regime. People want a way to express themselves and a little bit of humor and sometimes a little bit of winding down as well and winding up as well. And so we see that. So I don't want folks to think I'm against that. But what I'm saying is that our energy should be in the right direction also. And those of you who are in Trinidad and Tobago, for the opposition, Aubrey Norton and all these guys, they travel, they hold town hall meetings. This is just not about town hall meetings and collecting a few dollars for the party and these things. The energy should be focused in the right direction as well. And at least 100 folks in Trinidad and Tobago should have been in front of the Caribbean Court of Justice to mount this pressure so that Guyana can be removed and so that those justices, not all of them, mind you, there seem to be some good ones still, but the majority of the Guyanese people do not have confidence in the Caribbean Court of Justice. And therefore, whatever matter, political nature that goes there, people are of the view, and rightly so, that all of the rulings would be in favor of the corrupt, illegal PPP regime. We see this here where Anil Nandalal felt comfortable in making that post, albeit through his lawyer. Well, it's not his lawyer, it's a lawyer through the Attorney General's chamber. Hawk has said that it's the administrator. So suddenly, Anil's personal page has an administrator. Suddenly, that's the excuse. But then again, the folks in the PPP, they have the trademark of straying from the truth. But we will see whether another apology will be issued to the Guyanese people, to the Caribbean Court of Injustice concerning this premature announcement of the decision. So what has happened? Anil Nandalal, I want to repeat, Anil Nandalal ran on his personal page, carried the announcement that was just aired. He carried it. It was on his page. He carried it. It's right here. See, he carried it earlier. Oh, sorry. You can't see it. He carried it earlier, and then he removed it. The court's hearing shortly. He carried it, and then after they started to put some lashes on him, embarrassed him, he removed it. You see the sort of little boy games that's being played in Guyana, deceitfulness. You see it, gangsterism, fraud, all manner of games we see being played out in Guyana. So he removed that as well. He had that up earlier. He removed it. He had this up yesterday. He removed it. And then now he put another COI into elections on the horizon. In other words, he's talking about the illegal commission of inquiry into the elections. So something is wrong, not only with the entire PPP cabal who are illegally governing the country, but something is wrong with this guy. Something is definitely wrong. I saw this the symptoms of mental illness, a form of mental illness, when he was one of the persecutors in my illegal trumped-up treason case, that trumped-up treason case against me. During his argument, in order for my continued incarceration, unjust incarceration, Anil Nandalal said that Mark Benchap put his hand on Mother Guyana. Mark Benchap put his hands on Mother Guyana. But I want to say this to Anil Nandalal, that not only have you put your hand on Mother Guyana, you guys have done lots of things to Mother Guyana that would have caused all of you not only to be charged with treason, but all of you to be, okay, Mark, it's 11 o'clock. Just be careful, Mark. But you guys get the message that these guys are a pack of no good vagabonds heading the country. And every day they come up with these little visits into Belladrum. They walk around, and some guy asking them for $100,000, and they walk around with individuals, like you notice Anil moving around with Jason Abdullah and those guys, convicts, right? Jason Abdullah was sentenced to prison for throwing filth, I believe, in Freddie Kissoon's case. He's out on appeal. We haven't heard anything about the appeal as yet, but he's parading around with Irfan Ali and others. And that is where Guyana is at this time. Now let's get back and before we close up for now, that this particular matter with Anil Nandalal, and when we go back to his posts, his many posts meeting with U.S. Marshals, meeting with representatives of the Department of Justice, U.S. Department of Justice, and so forth, concerning folks who are wanted by the U.S. and their extradition request. Anil should let the public know whether recently he has received any request by U.S. authority to have individuals extradited to the United States of America. He should say whether he has, and I am almost certain that if he received any sort of request, that those who are wanted, some big so-called powerful businessmen in Guyana, so-called businessmen, are wanted for extradition. And the U.S. State Department and the U.S. Justice Department have to be, and other law enforcement agencies have to be very mindful with what they discuss and what information they send over to Anil Nandalal and his chambers at this time. And we saw the evidence right there in front of us. We listened to what the justices of the Caribbean Court of Injustices had to say about Anil Nandalal. And so I'm not sure what Aubrey's doing, but these guys seem to always have a strategy. They know what they're doing. They don't listen to anybody, and they feel that they want everything must come through them. But if I had my way again, Anil Nandalal's office would have had some people too. But what are they going to do? We recall one guy, Courtney Crummy Wing, who protested for weeks in front of Anil's office. And what happened? He was murdered. He was slaughtered. He was executed. He was assassinated. Not in front of Anil's office, but he was protesting in front of Anil's office. He was threatened. And according to what Courtney Crummy Wing did, he made a report at Brickdam Police Station about being threatened by Kwame McCoy, being threatened by Anil Nandalal, and all these manner of things. And so when Courtney Crummy Wing was assassinated, Anil Nandalal was, according to the public, a suspect. His driver, according to the public, was a suspect also. And so these are things that we need to remind the listening audience that Guyana has an installed, corrupt, murderous regime. And anything these guys say, and when they come to you and say about development and they mean well for the country and all these manner of things, do not buy into it. It's a fraud. That is what it's about. But, I can't read all of your comment. I just can't read all of your comments, but I will be back. I'll be back later on this evening. I promise you. I've been away for a couple of days, and now it's back to business. But before I go, this other issue with the DPP chambers. Nobody's talking about this. Nobody's sanctioning this woman for running the Director of Public Prosecution's office as though it's her personal entity. But we're glad, though, that the Chancellor of the Judiciary seemed to have stood our ground, so to speak. We haven't heard anything official, but the magistrate in the Bascom situation, is basically she recused herself, and what is not going to be made public, or what hasn't been made public, is that the magistrate in this Bascom's matter has been receiving lots and lots of death threats. Lots of death threats the magistrate received. Lots of death threats. And we know the corners in which these death threats are coming from. Hooligans who are close to Irfan Ali, and I really do mean hooligans who are really, really, really close to Irfan Ali. The same way the magistrate is receiving threats, death threats. It's the same sort of death threats, same sort of pattern when Claudette Singh was receiving her death threats as well. Same pattern, same entity, same bunch of people, same bunch of vagabonds, hooligans running Guyana. And so again, don't be fooled about this London stuff, and people can go to England. Of course, you can't just pick up and buy a ticket and travel. You got to go through a process. And I'd like to see some folks out in England, some folks who can't travel at all. I don't know if they might want to take a chance to travel to the UK and be picked up by law enforcement agencies. I don't know if some of those so-called big, powerful businessmen who are afraid to even go to Brazil or Venezuela border or Suriname border, but you see them pomposetting their wealth in Guyana. I'd like to see them take a plane and go to London or somewhere in England, and then from there, they can go on to Dubai and other places. But for now, I'll be back this evening right here on 107.1 FM. God bless you, and continue to pray for Guyana. We really have to continue to pray for Guyana. So long.
Making the short video for send to you and the viewers and listeners. I'll know we punishing in Guyana. Punishing. Rice gone up, sugar gone up, flour gone up, cost of living just gone up, gas gone up from 3,400 to 3,800. Real hungry days under this installed PPP government. Real hungry days we gone back to. Guyanese? Oh! Real hungry days, real hungry days.
Hello, this is attorney Shellen Washington, owner and founder of the Washington Law Firm located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.